Okay, so today I'm going to discuss with you probable cause in relation to search warrants. And in order to kind of help this explanation, I'm going to use a specific example of confidential informants versus citizen informants. It will kind of help to show what exactly goes into this, because as with everything in the law, tends to be reviewed on a case-by-case basis. So to start off with, I want to talk about some first principles. And we're going to start our discussion with Aguilar versus Texas. This is a case from 1964, and it regards the use of a confidential informant in forming the basis of a probable cause affidavit in order to get the search warrant to go and execute and search for contraband. In this case, we were dealing with a heroin possession, and law enforcement had the information provided to them by a confidential informant who basically was saying that there is some heroin there, and if you go and search for it, you'll find it. That's not everything that went into the case, obviously, but that just kind of gives us a basis. In that case, which went all the way up to the United States Supreme Court, the court eventually held that the confidential informant's information had to be corroborated in some form or fashion. Essentially, the issue is that they don't want the magistrate simply acting as a rubber stamp for law enforcement. When law enforcement brings a case to a magistrate and asks for a search warrant, they have to provide that magistrate with enough information to show that what they have from the confidential informant is reliable and that informant is credible. This was later expounded upon in Spinelli, which was another United States Supreme Court that came shortly after Aguilar. And Spinelli has kind of been construed later on as creating a very rigid two-pronged test that is based on the basis of knowledge of the confidential informant and the veracity portion, which is, how true is this information? What do we have to show that this person who is unnamed is being truthful? Those cases kind of set the bar for about 20 years as to how law enforcement could use confidential informants. They had to be able to show that they were both credible and that the information that they were providing was reliable. Okay, this started to cause some conflicts over time, and so then in the early 80s you have two cases, Gates and Upton, both of which were Supreme Court cases, and these kind of limited how the earlier holdings of Aguilar and Spinelli were reviewed. First of all, Gates replaced the rigid two-pronged test that most courts had taken out of Spinelli and just substituted totality of the circumstances. This was advisable because everything else that was related to probable cause, when you're talking about just, or searches without a warrant or any kind of police-citizen interaction, had always been based on this totality of the circumstances test, and so it didn't really make sense to have this rigid two-part test that was different for this one small issue. And so therefore they decided to just switch it and say it's always totality of the circumstances, which means, in essence, the court is always going to look at it at a case-by-case basis. There are no really hard, fast rules here. There are some guidelines, which we'll get to as we go on. But each case is going to be determined on its own merits. The other case, Upton, established that when law enforcement brings the affidavit, they have to be able to stand or fall on that affidavit. This sets up the four corners test, that the only thing that can really be reviewed by the magistrate to determine whether or not probable cause exists is the information that's contained in that document. There's no real opportunity to expand upon it, say by questioning the witness or the confidential informant. It has to be all in that affidavit. And if it's not in that affidavit, then it doesn't count towards whether or not probable cause was sufficient in order for that search warrant to issue. This helps for the appellate courts to be able to review when, say, a defense attorney files a motion to suppress on that search warrant at a later time, because the reviewing court may not necessarily have the benefit of those earlier discussions if they went unrecorded. So you have to keep everything on that affidavit. Now, what this essentially gives us, when you take these cases all kind of together, is that in order for probable cause to be sufficiently issued, it has to be based on the affidavit, and it has to be found completely within that affidavit. And additionally, you have to be able to provide enough information that can be reviewed by a magistrate independently of the law enforcement officer themselves or their conclusions, that demonstrates that there is a reasonable likelihood that evidence of a crime or contraband will be found at the location that you intend to search. Okay? So basically, they just don't want the magistrate to act as a rubber stamp. The magistrate has to be able to independently review it and make a determination on their own. Okay? Now, in order to kind of help explain this, we go to the examples of some more recent cases in Texas. These would be State versus Duarte and Elrod versus State. Duarte was decided in 2012, and Elrod came out in 2017. And these two cases really kind of demonstrate the difference between a confidential informant and what's referred to as a citizen informant. It does make the naming a little bit differently because as attorneys we tend to fall into acronyms. And so, we know what a CI is. That's a confidential informant, which you can see on any criminal TV show, law enforcement, or Law and Order, things like that. They'll refer to these CIs. Citizen informants are kind of the same thing, but it's someone who is actually being named specifically in the probable cause affidavit. And what those two cases dealt with was, what other information do you really need when you have these kinds of circumstances? In Duarte, they were dealing with an unnamed, first-time confidential informant. This person provided some tips about where some drugs were located. However, they were doing it in the hopes of receiving a beneficial resolution to their own case with the district attorney's office and law enforcement. Whereas in Elrod, you're dealing with a witness who, although was also facing criminal charges, was not giving the information in exchange for a better deal and was specifically named in the probable cause affidavit. And what Duarte says is that, excuse me, if they're unnamed, you are kind of going to need some more information. There's too much of an emphasis for them to provide self-serving information. Even though if it later turns out to be false, their deal might evaporate, it's still in their benefit to maybe oversell what they're saying, expound upon the facts or exaggerate the facts a little bit more than what they actually maybe know. And so in Duarte, the Court of Criminal Appeals issued kind of a list, and these are things that came from as far back as Illinois v. Gates and some of the other cases, but they kind of just bring it all together and show, like, well, if you have a confidential informant, you're going to need some other facts. The best and most useful one is going to be corroboration. You've got this statement from the criminal informant, and through law enforcement, you've been able to verify some of those facts that they are stating in their statement, and that kind of shows that they are being honest. The other thing is if their statement tends to subject them to further criminal charges or is otherwise a statement against their penile interest, that is something that you can also rely on. Most people don't run around, especially not in official government documents, making statements about crimes they've committed unless they've actually done it. And so that kind of gives an air of credibility to whatever they're saying. It's also helpful to have further statements by other criminal informants that maybe all kind of line up. While things from an individual's perspective can be entirely subjective, as with everything else, the more people that kind of agree on it, the more likely it seems to be true. You also have statements are deemed to be sufficient when they give a detailed first-hand account of things they saw. Something that when you read it, it's got probably too many details to be a lie. Most of the time, lies tend to be very general. They're not necessarily thought out, whereas actual observations, there's more facts and details that will appear in those, like, this room has beige wallpaper, which is not necessarily something that I would have come up with if I had lied about being here, as an example. They also have been found to be sufficient when they are coupled with accurate predictions of the subject's future behavior. An example of this would be a CI giving information, person X is dealing a large amount of heroin. About every Wednesday he goes and picks up a shipment from his supplier. And that would be located on the corner of Street Z and Street Y, for instance. Well, law enforcement can survey that person without getting a warrant. You can't really hide your movements within the community outside of your house, and they can watch them, and if they do go to this location, and they seem to go there every Wednesday, they walk in empty-handed, and they walk out with a big, duffel bag, well, that would tend to show that maybe what he's saying is true. And then the final one that the Duarte court kind of outlined is where the criminal informant has a successful track record. Some people, they get on as a criminal informant and then they never really quite get out of that. And law enforcement may use them multiple times. If a CI has a history of providing credible and reliable information, the courts are going to take that into account. Obviously, it needs to be listed on the affidavit because, like what we said earlier, that we're bound to that. But, it's more of one of those things that we've kind of developed a relationship with this person. They've given us good information in the past, and we don't see any reason why they would lie to us now. And so that's one way, that's how you can get a probable cause affidavit based on a confidential informant. Now, with a citizen informant, you don't really need to do quite as much digging. By virtue of the fact that they are named specifically in the document and they are subjecting themselves to new criminal penalties or just criminal penalties generally, as well as public ridicule and all the other problems that can arise whenever you lie to law enforcement, the courts are willing to accept their testimony as being presumptively true. All they are really looking for is did the info they provided, did it sufficiently detail enough information to suggest direct knowledge on their part? Basically, what that means is that, can the magistrate assess the citizen informant's reliability based on the details they provided in their own statement? So, for instance, does it look like it's valid? One way of kind of looking at this is, does it pass the smell test? If it just seems like an incredible story that could not have happened, well, then that's probably going to be disregarded. But if it seems like a normal story that you might get from a witness to a crime, or someone that was otherwise involved but who is also saying, I am specifically the person that was involved, then it's probably going to be held to be reliable. So the conclusion to all of this is that in terms of obtaining a probable cause to execute a warrant, a search warrant, the courts are at most concerned with making sure that the magistrate does not simply act as a rubber stamp. They want to see that the magistrate was provided enough information to independently make his or her own decision, on whether or not probable cause existed and that search warrant needed to issue. If there's any problem with reviewing their work later on, the Court of Appeals is more likely than not going to reverse it. Okay, if it was raised and upheld by the trial court. Additionally, they want to see that the magistrate received more than just a bunch of conclusory statements from law enforcement. It can't simply be, well, I believe him because he gave me this information, but I'm not going to give you his name, and you should just go ahead and give me the search warrant. That's not enough. What they want to see is that, well, he told me this statement, I'm not going to give you his name, but I did some surveillance work and I've verified that, X and Z are assuredly true. Y I'm a little bit unsure of, but I think I've got enough with just X and Z alone. Essentially, they want to be able to see that, this wasn't just simply law enforcement saying, I want a search warrant, this is why I think I should get it. They want to see that there is an actual basis for that search warrant to issue.